A collision of jurisdictions occurs when two or more legal authorities or courts claim the right to hear and decide on the same legal matter. This situation can arise when different jurisdictions have overlapping or conflicting authority over a case, creating legal complexities and potentially leading to contradictory rulings. Key elements of collision of jurisdictions: overlapping jurisdiction, conflicting laws, concurrent claims, resolution mechanisms. 1. Overlapping jurisdiction, multiple authorities. This occurs when multiple legal authorities or courts have the power to adjudicate the same case. These authorities could be located in different countries, states, or regions. Example: a business dispute involving parties in different countries may fall under the jurisdiction of courts in both countries. 2. Conflicting laws. Different legal systems. Jurisdictions involved may operate under different legal systems, statutes, or principles, leading to conflicting legal interpretations and outcomes. Example: a contract dispute where one jurisdiction follows common law principles while another follows civil law principles. 3. Concurrent claims. Simultaneous proceedings, when two or more cases are filed in different jurisdictions for the same legal matter, each claiming to have the right to hear the case. Example: parallel lawsuits filed in state and federal courts over the same issue. 4. Resolution mechanisms. Legal doctrines. Various legal doctrines and principles are employed to resolve collisions of jurisdictions, such as forum nonconveniens, comity, and conflict of law rules. International agreements, treaties, and conventions between countries often provide frameworks for resolving jurisdictional conflicts. Common scenarios leading to collision of jurisdictions. 1. International business disputes, cross-border transactions. Disputes arising from cross-border commercial transactions often lead to questions about which country's laws and courts should govern the dispute. Choice of law and forum clauses. Contracts may include clauses specifying the choice of law and jurisdiction, but parties may still disagree on their applicability. 2. Family law cases, divorce and custody. Divorce and child custody cases involving parties residing in different states or countries can result in jurisdictional conflicts. Abduction cases. International child abduction cases often involve multiple jurisdictions seeking to assert authority based on their laws and treaties, such as the Hague Convention. 3. Criminal law extradition. Criminal cases where the accused is located in a different jurisdiction from where the crime was committed can result in jurisdictional disputes over extradition and prosecution. Concurrent prosecution. Multiple jurisdictions may seek to prosecute the same individual for the same or related offences. Legal doctrines and principles for resolving jurisdictional collisions. 1. Forum nonconveniens. Definition: a legal doctrine allowing courts to dismiss a case if another jurisdiction is more appropriate for hearing the case. Application: courts consider factors such as convenience, availability of evidence, and connections to the jurisdictions involved. 2. Comity definition: a principle where courts show respect for the legal decisions and proceedings of another jurisdiction, effectively deferring to the authority of the other jurisdiction as a matter of courtesy. Application: often employed in international disputes to promote legal cooperation and avoid conflicting rulings. 3. Conflict of law rules. Definition: legal rules that determine which jurisdiction's laws should apply in cases involving multiple jurisdictions. Application: courts analyse factors such as the location of the parties, the place where the contract was signed or performed, and the place where the harm occurred. 4. Choice of law and forum clauses. Definition: provisions in contracts in which parties agree on which jurisdiction's laws will govern the contract and where disputes will be resolved. Enforcement: courts generally uphold these clauses unless they are found to be unreasonable, unjust, or against public policy. 5. International conventions and treaties. Hague Conference on Private International Law. A series of international treaties providing frameworks for resolving jurisdictional conflicts, particularly in family law, commercial contracts, and civil procedure. European Union regulations. EU regulations like the Brussels Regulation establish rules for determining jurisdiction and the recognition and enforcement of judgments among EU member states.